First of all, I'd like to thank the Bombay Chartered Accountant Society for graciously extending the invite. It is indeed my pleasure to address this August gathering in terms of all the chartered accountants who are present in terms of virtually, though I'm not able to see many of the others as well. But then at the end of the day, it's a Zoom conference and it's a one-way traffic. If anybody has any questions that needs to be put out, you can as well, if that access is given, please do put it out in the chat box. And before I can start, first of all, would like to even congratulate the BCAS for the 75th year, so on and so forth, which has been completed, which has been put out in the image which I am seeing. And aside from that, one part of it, the topic which has been given is the operation and mismanagement. Prima facie, this particular topic is so wide that it may take one single day in order to understand as to what this whole topic is all about. And in the corporate world, basically, chartered accountant plays a very huge role, and a role wherein they emphasize upon the decision-making capabilities also for the board. And thereby, at that particular stage, what is more important is with respect to the fact that the kind of strategies to be used, one, to take through the litigation, the strategies to be taken in order to ensure that litigation is not to be meted out, so on and so forth. There are issues like this that will come in front of many chartered accountants if they are practicing or if they are employed in a particular company. Because as the company grows or as the client grows, definitely the intellectual capacity of the chartered accountant gets utilized in all these issues. And at the end of the day, what matters is how effectively we are able to advise a particular client, right, in order to ensure that that a formidable solution is got for them. So thereby, before starting, as I always say, one thought process which always comes to my mind is knowledge forever will govern ignorance. Knowledge forever will govern ignorance. And those who all want to be their own self-governors have to equip themselves with knowledge. तो इसका मतलब क्या है? What does this mean? It means knowledge forever will govern ignorance. The first part of it means that those who are ignorant will always seek knowledge from the knowledgeable people. And since we are in the field of knowledge dispensation, we have to ensure that we update ourselves so that we are able to govern others or maybe guide others. So that is the sum and substance of the thought which has been put forward. And I can take the presentation flow in the subjective manner if Vipul sir gives a go ahead with the same. Can I start, sir?
Yes, we can start.
Yes. Profusely apologize to all the participants because of the technical glitch. We could not immediately log in terms of the presentation. But since it is now, it has been done. क्या हम शुरू करें क्या? क्या हमें शुरू करना चाहिए कि नहीं करना चाहिए? मैं आपसे पूछना चाहता हूं. I believe my profile would have been read out before.
Right.
No, since the technical glitch was there, I thought that I've taken the liberty to assume that my profile would have been read out earlier, which also contained one line that I'm a mimicry artist. So on and so forth. First is with respect to the fact, the flow of the presentation that I'd like to take it across is with respect to the fact that what is operation, what is mismanagement, what is the meaning in terms of operation and mismanagement, what is the basic distinction, what are the kind of companies which go through this particular process, and subsequently in terms of what are all the cases which today are finding out the headlines in the papers insofar as this is concerned, how chartered accountants become an inevitable tool insofar as all of these advisories that needs to be ensured to the promoters or to the shareholders that needs to be given. Aside from the fact that all of these are there, some of the case laws as well, which will be dealt up, is one such case which even on which I had fought and which had gained a lot of recognition in papers, which was with respect to technology frontier. That would also be discussed as a means of a case study to ensure that the basics and the strategies are understood in a very well and lucid manner for the audience at large. So starting this introduction, first slide, please. Companies Act 2013 aims to protect the interest of shareholders and stakeholders. Now, when we say this, what is the first line that it comes across with reference to in the mind? What it comes across is that in the earlier Companies Act, there were a lot of loopholes which were there, which people used to utilize. Now, one such loophole, which I may say, is the fact that people used to increase the shares, but they would not give any notice. People will conduct rights issue, but they'll not give notice to the other side. But cut to the new Companies Act 2013, 1956 has gone are the days which are now it is not even applicable. Now, since 2013 has taken shape and it has been all the more than 10 years that it has been in operation, the issues pertinent to increase in share capital by one side alone has taken a deep hit. It means, in the sense, what I'm talking about is that earlier, there used to be a lot of operation and mismanagement cases where we used to see that uh, the other side does not even know that the shares are being increased, and suddenly they find in their annual returns that suddenly the percentage of their shareholding has decreased. Now, if a company has to do a rights issue, it has to ensure that it sends to all the stakeholders the emails, the separate bank accounts have to be opened, so on and so forth, in terms of other compliances which are there enshrined under 62(1)(c) of the Companies Act. All that has to be done. Earlier, these were all the deterrents which were not there earlier. Thereby, what used to happen was that lot of it used to be taken for granted by the promoters in order to increase their holding and scuttle out the minorities. Thereby, today, as we stand, these per se has taken a huge dip in the cases per se that we see in terms of operation and mismanagement, particularly in tune with increase in shareholding by rights issue. Earlier, this itself used to be one exercise where many of the professionals were used to be involved in. Further, operation and mismanagement provisions are crucial to ensure fair treatment within companies. When we say this, the treatment per se, many of the times we'll find that most of the times, after having fought a legal battle for a very long period of time, the parties would come down for the purpose of settlement. Ultimate aim or ultimate case that comes out to a closure is one which gives a fair settlement to both the parties in hand. So in the case of operation and mismanagement, usually it is a long battle. It has to be fought from the perspective of both the sides. And the side that which you are in, you need to ensure as to what kind of strategies that you are going to adopt, wherein you ensure that the other side comes to a form of a settlement at least. And prior to even starting out in terms of strategizing, the more important aspect is to ensure that somehow we know that we are able to let the litigation not take a shape. That is to say, what are the modes and methods which are available to a particular party to ensure that the litigation does not take shape will also be dealt in this particular presentation by me. Now, coming to the next slide. Now, from where to where does this particular operation mismanagement cover? Prima facie, if we find the main sum and substance is the core of the heart of the whole chapter that lies with reference to operation and mismanagement is 241 to 244 of Companies Act. When we say 241 to 244, it starts from the fact that somebody should have been aggrieved by the cause of action. It should have some form of an agreement by a particular member who feels that either of his rights have been somewhere dealt in a manner which is prejudicial to his interest or the public interest, and thereby he gets the cause of action. In a legal parlance, cause of action means that from where do you start? That is to say, what is your locus? 244 of Companies Act is all the more essential because here we test the maintainability of a particular application that gets filed with the NCLT. Now, what is 244? 244 basically means 10% of the holding should be there in a particular company for you to file a case either singly or jointly with other people in order to maintain a particular petition of operation and mismanagement in the NCLT. Now, certain categories of exemptions are found in 244. That is to say, you may be given an exemption from this 10% holding, provided you are able to convince the bench that how this is important issue that needs to be dealt. And as a minority shareholder, it is very, very imperative for the tribunal to consider their rights. Thereby, it is not a birthright for a particular person to get inside and start litigating if you don't have 10%. You need to ensure that you cross that particular threshold, that 10%, if it is not there, you need to convince the bench that this is one such particular case where even if it is 10% is not there, it has to be dealt by the tribunal. A classic example of that particular case was of Tata Sons versus Mistry. So that is where one of the cases which was there, which was dealt by NCLT Bombay bench, and subsequently it went on to NCLAT, and finally it saw the light with reference to the Supreme Court granting the relief in favor of Tatas. So that was one case where 244 also got highlighted because the requisite 10% was not there for the purpose to start up the litigation. So thereby, it depends on case-to-case basis. If you do not have your 10%, then in such a case, the 10% has to be looked upon from the perspective of a particular judge who needs to get convinced after you file a petition. And yes, oppression and mismanagement in simple terms means acts which are harsh, burdensome, and wrongful. That means something which is wrong, which has happened to a particular shareholder, and something which is burdensome, and something which is wrongful. These three are the main constituents or pillars to determine a particular oppression and mismanagement in a particular company. So thereby, this being said, next slide, please. Provisions under which the Companies Act gets covered under, it's the chapter 16 of Companies Act 2013, where it gets covered under. Section 241 deals with the oppression and mismanagement. Clause A deals with oppression and mismanagement. Clause B deals with mismanagement likely to occur on account of change in management. Now, when we talk about clause A, which is with reference to oppressive act, something may be legally correct, may not be oppressive. Something may be legally incorrect, but will be oppressive. So thereby, this part of the case as well, we will deal in the slides to come. Next. What does 241(1)(a) deals with? 241(1)(a) deals with covering continuing acts which have been concluded, meaning to say, any act which has been done by a particular majority shareholder or any other shareholder to a group of shareholders has to be a continuing act. An oppression case has to be that which is a continuous act, and it should not be a case that one-time act it has happened and subsequently there is nothing in so far as an oppression which can be decided upon. So thereby, one needs to see that whatever the acts which are being done to a particular person, the effects of it has to be a continuing one, and the acts also has to be a continuing one. Any member who complains that the affairs of the company have been or being conducted in a manner prejudicial to the public interest, or so on and so forth, in a manner prejudicial or oppressive to him or any other member or members, so on and so forth. Like I said earlier, it should be prejudicial to the interest of his, or to the prejudicial to the public interest, or oppressive to him. So thereby, this particular basics that we know of is 241(1)(a) of Companies Act 2013. Next slide. Well, prerequisite for the purpose of filing a particular case, as we know, 100 members have to be there if you wish to prefer to file an oppression and mismanagement company. If in case lower of one, that is to say not less than 100 members of the company, not less than 1/10 of the total member of the total number of the members, or any members holding not less than 1/10 of the issued capital. That is to say, in simple terms, 10% is required. Now, if 10% is there, not there, then like I said, 244 comes into the operation, and thereby you need to convince and then move forward. That is, if you don't have 10%, you'll go through the process of 244, and then alone you will be able to take the case forward. The company not having a share capital, then not less than 1/5 of the total, 1/10 of the total number of members. Again, the same criteria that needs to be looked upon. Now, 241(2) is one other section which is quite frequently these days applied insofar as companies like Videocon and others, ILFS, so on and so forth, have been done. The central government also may directly jump into the prospect of oppression and mismanagement, and directly, if it is in its opinion that the affairs of the company are being conducted in a manner prejudicial to the public interest, then the government itself can start applying to the NCLT for the purpose of taking the case through. Next. Meaning of oppression, well, again, few basics. We are going through the basics only to ensure that at the end of the day, we have certain form of good understanding of the subject. Well, oppression, it originates from the fact that Foss versus Harbottle was the main majority rule, which was established way back in 1800s. According to Lord Keith, oppression means a lack of morality, fair dealing, so on and so forth, which is prejudicial, and it includes unjust, discriminatory, oppressive action towards the shareholders. In simple terms, something which is harsh, something which is burdensome, are all the actions which come under the process of oppression. Next. Examples of oppression. When we say what is the examples of oppression? Well, there are many examples of oppression. That is to say, one, if we see dilution of voting rights or ownership, suddenly you see that your shareholding has decreased in a particular company. There has been increase in the shareholding of a particular faction of shareholders, which has been done by the directors through the roots of rights issue or any other issue that they may undertake, or conversion of a particular share, which is not taking the permission from the shareholders earlier, and subsequently they convert the share. That may also be a cause of an oppression that may happen. That may lead to the prospect of dilution. That is to say, you have rights issue, you have conversions, you have a preferential, so on and so forth. When in such a manner it has been done, in order to ensure that your holding has been limited or minuscule to the extent that you do not have a voice, then those are all considered as a means of an oppression. Second, unreasonable transfer restrictions are also being placed. That is to say, law allows to impose certain reasonable restrictions. That is, in so far as private limited companies are concerned. Most of the cases which come to the NCLT are cases of private limited companies, because in many of these companies, there is no maintenance of any records and data. And at the start, when the company starts, most of them are being run like a proprietorship. And subsequently, when there is some dispute, that is when they realize that, yes, certain part of the law that they need to follow. And suddenly this realization makes them to change certain, their AOA, their MOA, so on and so forth, to ensure that there is certain restrictions which comes under, which is beneficial to their holding. So thereby, insofar as unreasonable transfer restrictions are there, that may also come under the prospect and the ambit of oppression. Restrictive determination of share value. In some case, the company or its controlling ownership might require a minority owner to provide them a right of first refusal before selling. Often this transfer value is fixed at an amount far lesser than the actual value. Now, when we say this, what are we talking about? See, I'd like to take you through one of the cases which is with reference to Valli Murugappan, a case of Murugappa group-based company, where there was close to around about 8.33% worth of a holding by the two ladies, which was there in that particular company. And at the initial level, the valuation which was being spoken about was far lesser than what they wanted to negotiate. So thereby, restrictive determination of share value is also a form of an oppression insofar as the Companies Act are concerned. That is to say, if the shares are valued at 500, But if the other side is offering only 100, that is also one of the cause of concern which may be considered as an oppressive act. Denial of access to records, that is also one of the aspects that can be considered, because as a shareholder, you are not only the owner of the company, you are also one of the persons who has all the moral rights to ask certain details which are there with reference to the company. Thereby, when you are restricted or you are denied insofar as the records are concerned, there your cause of action again arises to go ahead and also file a case insofar as the oppression is concerned. Employee termination. Well, this is a new form and a concept which is being brought about, because these days we are seeing a lot of ESOPs and ESOS, so on and so forth, getting allotted to the employees. But then insofar as the allotment is concerned, if that is not done, or that is something which is done insofar as prejudicial aspects are there in that, then that also may be considered as an oppressive act. Withholding dividend payments, that usually these days we do not see this particular reason, but in earlier times, this was also one of the reason as to why the companies or the shareholders used to go for the purpose of operation and mismanagement case in CLB, so on and so forth. Exclusion of minority shareholders from decision-making process. Well, in earlier times, in 1956 Companies Act, there used to be small-scale shareholders as well. That particular form of a concept today we do not see, which is there insofar as the board of bigger companies is concerned. So thereby, the voice is not there in the board to represent those small shareholders. And yes, in most of the cases, as we see, diverting companies' funds for personal gain by majority shareholder is definitely one of the major prospect as to why the shareholders run to the NCLT. That is prima facie because of the fact that most of the cases, the company funds gets diverted or usurped by one or the other director, or who may be a shareholder also. Thereby, these are all the examples of oppression which takes place in a particular company. An operation may also take place insofar as if certain notices have to be sent to a particular shareholder or a particular person, but it is not sent by the set of faction of majority shareholders who are directors as well in the company, then that act may also be termed as an oppressive act. That is seen in many of the earlier cases of Companies Act. That is Shanti Jain's case of Kalinga tubes, which is there insofar as that particular matter is concerned. Next. Mismanagement refers to improper or inefficient conduct of the company's affairs. It includes action detrimental to the company's interest and mechanism for addressing instances of mismanagement within a company. Now, what do I mean in this? Well, basically, when I say this, it prima facie means that mismanagement is little bit different. Mismanagement is to the accounts where the current management is not able to realize as to how that particular company is supposed to be run. That is also one of the cause of action where to which a person may go ahead and also file a case. Till now, is everybody clear? Text. So mismanagement refers to improper or inefficient conduct of the company's affairs. So it is little bit distinct, and it is also something which is not insofar as same as oppression. Oppression means an act which is purportedly done. Mismanagement may occur with a particular naiveness also. It may not be with a purported illness that a particular person may want to bring this particular action, but it may be on account of the fact that mere innocence also. It may be that mismanagement may be brought about in a particular company. Next. Difference between oppression and mismanagement. Basically, difference between oppression and mismanagement, relief against oppression runs favor of individual members of the company. Relief against mismanagement is granted to the company as a whole. In simple terms, if you go to the court and you pray for certain reliefs, that my lords, I want X or Y or Z as my relief, but in so far as oppression and mismanagement together, when you file a case, it runs in favor of the individual member of a particular company. He may want the shares to be freezed, or he may want certain reasonable restriction that maybe needs to be imposed. But insofar as mismanagement is concerned, relief which is provided runs against the company. Let's say, presume, if I want to have, I want to ensure that a relief such as blocking the bank account. That is to say, bank account need not be utilized by a particular set of directors, then that relief will be considered for the purpose as a means of mismanagement that they are doing. Say, for example, some hotel is there which is running, and it requires, on a day-to-day basis, certain funds to be collected from the customers. And if a certain section of shareholders today find that this particular money is being utilized in a prejudicial manner, then the first relief can be for the purpose of mismanagement as well, which may be to the tune where they may ask, kindly freeze that particular bank account. Ensure that you separate you establish a separate escrow account wherein this particular money can be put up. So thereby mismanagement is granted to the company. Now company is the one who is the beneficiary, because at the end of the day, if you block a particular bank account or you put an escrow account, it is with reference to the company's bank account is what you are playing with. So thereby relief is against the mismanagement is granted to the company as a whole. To get a grant against operation necessary to ensure that there are facts to justify making of an winding up by order. See, basically, in an operation and mismanagement case, there are only three alternatives which are possible. You continue a particular litigation till the end, but three prospects which are technically possible is either the other side buys you out, or you buy out the other side, or third, you close down the company. These are the three things which are possible in an operation mismanagement case. Either you buy out, or he buys you out, or the third prospect is with reference to the fact that the company may be closed, and thereafter whatever is there in the company may be liquidated in order to get the funds which can be distributed to all the shareholders. So thereby, in an operation and mismanagement case, whatever the acts are being complained of by a particular party, that is to say, if today I am complaining that this X person is doing some activity which is causing harm to the whole value proposition of a particular company, then that act needs to be stopped. The acts which are complained of needs to come to an end as a means of effect for an operation mismanagement case. Meaning to say, जो हम मांगते हैं, meaning जो हम complain करते हैं, whatever we complain, that complaint has to be redressed, and that redressal comes only by means of these three basic fundamental principles, which is one, either you buy me out, or I buy you out, or we close down the company and ensure that at the end of the day that the whole money is taken by all of us in terms of the proportionate of our shareholding. So that is something which is there as a means of an end for an operation and mismanagement case. It is enough if the affairs of the company are conducted in a manner prejudicial to the interest of the company or the public interest. So thereby, what are we saying? We need to ensure that we have to convince the bench that this particular company is being run in a manner which is prejudicial to the interest of the company or the public interest. Now, say public interest is where you find that, in cases like ILFS or Videocon, so on and so forth, in all of those cases, directly the government jumps in. So thereby, which is against the public interest, the government may also have a say in so far as those cases are concerned. Next. Circumstances which, like I said earlier, what are the two circumstances? One of the circumstances with respect to the affairs being conducted in a oppressive manner, and the other one is material change undertaken which is not in the interest of a particular company. That is something is what is mismanagement, which has been discussed by us earlier before. Next. Who can file an application? We had already discussed this. So 100 members or 1/10 of the total members, whichever is less. Again, reiterating this issue, because many a times this becomes the core issue for the fact that whenever whosoever is aggrieved wants to approach the tribunal, this is the first roadblock that you need to cross. Once you cross this roadblock, that is when your petition or an application will get heard in the court. For the companies which are having share capital, this is the bare minimum is what is required. For companies not having share capital, then 1/10 of the total members are required. So thereby, these are the two fundamental distinctions which are there insofar as having capital and not having capital for the purpose of filing an application with the NCLT. Next. Powers of the tribunal, presuming today, you take a particular case and run to the tribunal and ask, my lords, please give me something as a means of a relief. I am aggrieved by so and so person acting against the interest of the company. Then what are the powers that a particular tribunal has, which it can ensure to regulate the conduct of a particular company? Well, NCLT has been established under Section 408 of Companies Act 2013 after a long drawn battle under the prospect of Madras Bar Association, wherein versus Union of India, wherein this tribunal came into existence long back in 2016 December. So at that point of time when it came into this picture, Section 430 of Companies Act was also live. That is to say, Section 430 of Companies Act ensures that there is no other civil code that you can approach for problems which arise out of Companies Act. That is to say, if a shareholder is aggrieved, he has to approach first to the NCLT. He has a choice to approach even the High Court, that is separate. But if the High Court deems fit to interfere in a writ petition, that is a separate cause of action that needs to be seen. But generally, most of the civil courts as of today, under the pretext of Section 430 of Companies Act, do not interfere insofar as operation and mismanagement is concerned, and the full power that is to be decided in such kind of cases is laid down only with NCLT. So the NCLT today is so powerful to decide all such cases which are relevant to operation and mismanagement, and not only operation and mismanagement, barring a few cases which are there, which comes under few sections which come under the special code that are with respect to the criminal sections which are there under the Companies Act. Rest of all the other sections can be handled by the companies, by the NCLT itself, by virtue of Section 408 of Companies Act coming into the picture, and by virtue of the fact that the power of the tribunal being there, which is sky high on account of the fact that under Rule 11 of NCLT rule, the NCLT can give any form of a direction to ensure to regulate the conduct of the affairs of the company. So Rule 11 is much, much wider. So if a particular person complains of any mismanagement or an operation in a particular company, then the NCLT can frame order by means of pretext of even Rule 11 of NCLT rules. So thereby, regulation of the conduct of affairs of the company is also one such power that the NCLT has. Now, when I say regulation of affairs of the company in future, what do I mean? Well, basically, certain times we see that in many of these companies, administrators are appointed. Now, administrators can be anybody by means of a choice of a particular person. That is to say, if two parties are litigating, that is myself and the other person, we both also have a choice where we can go to the tribunal and say that at the end of the day that I would like so and so chartered accountant also to become an administrator of a particular company. So regulating that particular conduct is left to the NCLT, whether the NCLT would like to take this particular proposition which has been brought forward by the parties for the purpose of regulating its conduct, that an administrator can be appointed. And most cases, it is the retired judges who get appointed as administrators. But then administrators, or the role of administrators is such that to ensure that the company functions, and that is something which usually gets decided through the prospects of an NCLT, when the NCLT blesses that person to take over the affairs of the company, to run the company. Purchase of shares, interest of any members of the company by other members. Now, a classic case to this, if I'd have to say, is one part of it is everybody would be aware that there is a case of Kirloskar which is going on in the NCLT Mumbai, and where long drawn battle is going on between the brothers. and wherein just a week or 4 5 days back, the order has been given by the NCLT Bombay bench, wherein one brother's shareholding is supposedly first to be offered to the other brother. And after that, if the other brother does not buy within a period of 30 days, then it can be put up for the purpose of normal aspects of trading, and it can be bought out by any other third person, so on and so forth. So thereby the NCLT can direct purchase of shares or interest of any members of the company by other members. As simple as it is. So thereby giving you a classic practical example wherein the other members can also buy out the other parties. If any shares are purchased, it's consequent reduction of share capital. Now, how does this function? This has a different mode and modalities insofar as if it is getting purchased. So that is the different form of scheme that needs to be introduced. That is also another prospect under the operation and mismanagement, where people do those activities as well. And subsequently, restriction on the transfer or allotment of share is also one such power that the particular NCLT has, where it can ensure that transfer of shares can be stopped. Now, if we have to take this plea, how do we take this plea forward? Now, how can the transfers be subjected to some form of a restriction? Now, a classic example of that would be there is something known as beneficial ownership under Companies Act. Now, which comes under the prospect of Section 89 and 90 of Companies Act, where the person has to declare his ownership, who's the last leg person, that is live individual who's holding a particular share if it is a corporate. That is, whether who's that individual holding the shares in a corporate, which is the first and masked entity. So when we say that, what is it that we are talking about? Now, if in case the person does not show or does not uh, showcase or disclose in Ben 1, Ben 2, Ben 3, so on and so forth, those forms, and file it with the ROC, then the company per se can also file this case in NCLT to freeze the shareholding of that particular shareholder. That is also possible. That can be also a case which can be brought under the prospect of oppression. And that can be also a case where a proper strategy can be devised if an individual is holding such, if the company is holding such shares and it is not disclosed for whatsoever reason as to who are its beneficial owners, then the freezing or transfer restrictions are being put up by the tribunal. Termination, setting aside, or modification of any agreement between the company and its managing director or any other director or manager. Many cases, while termination or setting aside or modification of any agreement between the company. Now, if I have to say this, the powers of the tribunal, if you see the one which got decided, Tata versus Mistry case was one such case where Mr. Mistry was purportedly he had left the company, and thereby NCLAT had immediately again reinstated him as a chairman in that particular company. Thereby, the termination was not the termination, the resignation was set aside, and modification of any agreement by the company, all those things can also be done by the tribunal. That is to say, the powers of the tribunal are so wide that it can be done through the prospects to ensure that the aspects which are being complained of, it is put to rest. Any oppression or mismanagement. Next. When will the NCLT interfere? So NCLT interferes at the point in time when, like we said, that it is prejudicial to any member or company's interest or winding up, so on and so forth. In the earlier case laws, if you see the Kalinga tubes or the ones which is needle industries, these were all the case laws on which the whole oppression and mismanagement cases were being fought in the CLB in earlier days. That is Supreme Court in the needle industries has clarified that an unwise, inefficient, or careless conduct of a director in the performance of his duty cannot give rise to a claim for relief under that section. Now, what does this mean? If a director is not performing his duties, then in such a case, you cannot claim. You cannot come under the prospect of oppression and mismanagement. Complainant should typically demonstrate that the conduct is unfair, lacking probity, and prejudices the exercise of his legal proprietary right as a shareholder. That is to say, when you are complaining about something, you should know that how you are getting affected. If you are not getting affected in any which manner, then in such a case, what happens is that the court will not grant you any relief. So thereby, the first aspect is to know what you have got hurt of and what is the relief that you are claiming about. So thereby, merely stating that the director is doing X, he is doing Y, so on and so forth. Now, whatever he is doing, how is it affecting your rights as a shareholder? You have to ensure that you have to tell all these things. Next. Now, the most important aspect. Now, where do we talk about operation mismanagement is all fine, sir. But how do we ensure that the preventive measures come into the picture? Now, when we talk about preventive measures, first, whosoever it is, internally, if it is a company which is functioning and you are the CFO as a chartered accountant, so on and so forth. First, an internal discussion should be there. And insofar as the chartered accountant in practice is concerned, he needs to ensure that a client's discussion ought to be there with him. First, to understand as to what is the issue which is being complained of. Second, one understanding from right from the start to end is necessary, but understanding the behavior of the other side is very, very important. So a little bit of psychology also needs to be done, needs to be known for a chartered accountant, because of the fact that instead of entering the litigation space, before itself it can be curtailed on account of the fact that if we can bring the parties, aggrieved parties to the table to ensure that they settle, there's nothing like it. As olden days and current day also, the Atalad place, baate gira deti hai, faslo ki diwarein. So ensuring that there is a certain amount of dialogue that happens between the parties is also one of the important methods through which the operation and mismanagement cases can be averted. But behavior of the other side is very, very important. You may want to dole out certain form of you know you may want to ensure that you want to settle with a particular party, but the other side's behavior is such that if he doesn't want to come to the table, then you cannot do much about it. Then the next set of strategies which flows on is typically a go hard strategy that will come to it. Understanding the financial capacity of the other side. This is one more aspect that a person needs to know, because in any litigation, what matters is the ability to fund. If you are not able to fund for a longer period of time in cases like this, longer in the sense these days, NCLT, NCLATs have been disposing matters in 1.5 years, insofar as even the Companies Act matters are concerned, apart from the IBC cases that they look upon. But if the financial capacity of the other side is known, what technically it does is that it ensures that you plan it right. It ensures that the strategy to know whether how long the other side will be capable enough to run a litigation, because litigation is time consuming, litigation is cost consuming, litigation is also something which is mind consuming. So all the three things, it starts insofar as the litigation is concerned. If that has to happen, we also need to know if the other side will be able to fund it for a longer period of time. Understanding the influencers of the other side. That is to say, first and foremost, when we know that the other side is an errant party wanting to gain control because of greed, need, or maybe perhaps he wants, his vision is something which is different from yours, then first we need to understand as to who are the influencers of the other side, through which a mediation can be set up, through which a person can be approached, because these are all some of the fundamentals which are required at the startup stage to ensure that the litigation does not step further. Understanding the influences means to first call out who are all the parties, like related parties, relatives, promoters, so on and so forth, friends, family, etc., where you can reach out to that particular person through some other banner. It is always better not to reach out directly, but to reach out to someone else, so that to get a feeler whether a person really wants to litigate, or he wants to stop all this and get out of a particular company, or what he wants to do with it. Sending off the record feelers, like I said, it's better to ensure that some form of feelers are being sent to the particular person. And drafting clear cut rules for investor. Many a times these days what is happening is that it's becoming a state of startup world, and in a startup world where we are seeing increasingly the investors are coming inside, and suddenly when the startup does not do well, the first petition that goes out in the particular NCLT is with the operation and mismanagement. Now, at the start stage itself, the roles and responsibilities as well as the investor related clauses are perfectly drafted. Then preventive measures are always there. There are ratchets clauses which are being drafted, that is to ensure that if the promoter does not do X or Y or Z in a particular company, then the holdings will be reduced to that extent. Thereby, the parties needs to be clear at the first stage itself as to what they are getting into, so that on a later point of time these issues does not arise. More or less in our Indian community, what happens is that first they start the company, and then thereafter, once the company starts becoming big, that is where all the litigation starts coming in, and the paperwork is left to the chartered accountant or a company secretary or a lawyer to look back upon or fall back upon when in the times of their need, not in the times of the company's need, in their need. If at all, if they want to file a case, at that point of time, a chartered accountant may be approached for. So thereby ensuring that you have a perfect SHA, SPA, that is the need of the IR at the startup stage itself. Demarcating director's role, very, very important. Under the pretext of 166 of Companies Act, that is fiduciary duties and roles and responsibilities, many a times you'll find that the directors will take a lot of money out of the company through their own entities. So it is better that you have director-based agreements with the directors as well, where certain do's and don'ts are already kept in place. If that is done, then most of the times you will find that in Companies Act itself, it is clearly given that under section 166, that a particular director should not take out cause any loss to that entity in which he is working, and cause by virtue of his act and actions. So thereby it is very, very important to demarcate the roles of the directors as well. That is one such way of preventing such measures. Knowing the soft targets. Now this is also one such activity. If you're the person, your person is an aggrieved person, then you should know who is the other side, in your other side, who's the soft target, whom you can target and ensure that you can bring him to the table. That is to say, for example, if the person is afraid of any authority, so on and so forth, then you already know that there are a lot of non-compliances which are happening in a particular company. Then it is better to first only write a letter and to educate and elucidate with reference to that. If at all, if the person is knowing those aspects and still wants to be abrasive about it, then the legal battle is on cards. If at that juncture itself there is a phone call which is put up between the parties, then it is better to close through those measures also. So knowing the attributes of a particular person on your other side is one of the most important quality that you as a person who's there in between needs to have, because of the fact that you will be the bridge who will be bridging the both the parties together. So thereby these are all some of the important preventive measure. Going through the MOA and AOA of a company is very, very important. Why? Because a lot of the other times we also find that some other track is being taken up by the directors or members, directors who are members, which are not there as a means of an object of a particular company itself. So thereby, what essentially happens is that you need to be aware of your MOA, OA, and thereby you need to have at least one love letter being sent to them to ensure to fall in line in so far as that is concerned. Going through all communication, emails, agreement entered into between the parties. These are all some of the things which ensures that you can remind a particular person to take a back step. Studying the annual return reports and being prospectively aware of what is happening in the company is also one of the ways where you are educating, self-educating yourself to ensure that you play a bridge between the parties. So thereby, these are some of the preventive measures, but the strategies which come out is with respect to slumber mode strategy, go hard strategy, and all what do you call all out attack strategy. All these things are there in which are technically being fought in US though, but in India, most of the people do not enter into this realm of space because lack of awareness is there in so far as these are concerned. Because litigation is merely for a case dalna hai bas. People don't know as to, even at the end of the day, if a case has to be fought, how it has to be fought, whether there needs to be a strategy, how it has to be perfected, what moves have to be taken in order to ultimately achieve what is supposed to be achieved. That is the three issues: either you buy out, I buy out, or you be close the company. So thereby, in this to happen as well, there needs to be clear cut boardroom as well as the consultant based strategy that needs to be gone in, so that a person is able to arrive at some conclusion which he knows that within a time frame I'm going to achieve these results. If you are a person who's suffering an operation mismanagement case, how to ensure that you are on a slumber mode? These are all other things that needs to be done, because when the iron is hot, people will strike. It is better to ensure that some water flows under the bridge. Thereby, after a point of time, you can take your turn to ensure that you make the other party come to the table. So these are some of the preventive measures which are there in so far as the ensuring the operation and it does not culminate into an operation and mismanagement case, because most of the time the parties are not aware of their rights, and when they are not aware of their rights and suddenly they get up and say, oh, my shareholding has decreased, oh, I have been removed, oh, I have not been given certain responsibilities, or some other person has increased certain holdings, so on and so forth. And these are all some of the times you will find that no, because of non-proactiveness is what this litigation gets triggered. And when the company becomes as large as an elephant, that is the time people start realizing their rights as well. So thereby, preventive measures do definitely take into consideration that certain of the aspects can be looked upon earlier itself in order to ensure that it does not culminate into litigation. Next. Now, when we are talking about what is operation and mismanagement, prior basis itself, there are many a times that mediation is being and getting encouraged in uh, so far as the operation and mismanagement cases are concerned. Section 442 of Companies Act is one such section where we will find that as a professional, we also can get empaneled with the government, and you'd be surprised to find that I could not find insofar as the MCA is concerned this data insofar as western region of Bombay, that is western region of Maharashtra. I could not find who are the empaneled mediators in section 442. Though in the southern region and northwestern region, the list is there where close to around about 24 empaneled mediators are there insofar as this is concerned. This is a very good opportunity for the chartered accountants to get themselves as well enrolled, because of the fact that this can be utilized by them to act in cases where operation and mismanagement happens. They can also tell their client that they are also certified mediators and are appearing onto the empanelment list of the central government is concerned, and thereby their services can also be made use of the same. So if you see, the government also comes out with a particular list where they put out the criterias, and the criterias which are there, criteria for the professional, and especially since the gathering which I'm addressing today is chartered accountant, 15 years of continuous practice or chartered accountant needs to be there, thereby in order to ensure that you can become a mediator if you want, and to get yourself empaneled. So thereby, many a times at the start stage itself, when the litigation starts, the benches do prescribe the fact that they appoint retired judges as a means of administrators. But then if a party pushes their own people inside in so far as mediation is concerned, then it may also help to take things forward. That is to say, mediation has to be independent, and it is between the parties. There is not much of role that a mediator per se has. It's only facilitating an arrangement, but this definitely lets the ice break through. And this is one form of an opportunity which a chartered accountant can maybe look into it. Next. Role of government. Basically, role of government is in today's times, due to the fact that there are a lot of issues that keeps happening insofar as big companies are concerned. Though big companies may become insolvent as well, certain cases are filed insofar as operation and mismanagement is concerned, where you will also find the inspector and investigators getting appointed through the virtue of 241 subclause 4, 2, so on and so forth. Now, what happens in this? Say, for example, if the government feels that a particular inspector investigator has to be appointed, it can do so under the prospect of Section 206 of Companies Act. Now, who are generally the inspector or investigators are basically the regional director who functions under the prospects of the central government. So thereby, under the 241 of Companies Act, where the government is also becoming one of the litigant, you may also find that even in an insolvent company as well, these cases go through. And one of the other cases where an insolvency company, where an RP initiated the investigation, was Lagdapati Ramesh case, where in spite of the fact that the insolvency was going on, and inspectors were appointed for the said purposes to ensure that inspection is done inside the company. Usually in insolvent companies, there are only 2 years that you can go back apart from the fraud related transactions. So thereby, in case the government wants, they can also take this route for the purpose of appointing inspectors and investigators. So thereby, this is one such role of a particular government in a larger scheme of fraudulent activities which happen in a particular company. That is operation and mismanagement. Next. This is one such case. Once long back, a few cases that we are dealing with and dealing with in this presentation. This is one of the first case. And an object clause was changed. People were smart in the earlier times. What they used to do was they sold their company. Hindustan Cooperative Insurance Society Limited was sold to LIC because of the regulations which were brought in at that time, that only one insurance company needs to be there. So thereby what had happened, this company was sold, and thereby the shareholders at that point of time majority shareholder changed the object clause in a manner that all the gains that were being made through the such sale were being given only to majority shareholders, and the minority shareholders were scuttled out. So thereby, Calcutta High Court had given a verdict that such kind of oppressive object clause need not be there, and it has to be strike down, and thereby that act was held as oppressive insofar as that case is concerned. So thereby, when you change an object clause also for the benefits of few of the person, that also falls under the ambit of operation and mismanagement. Next. Next is the case where the the person, the vice chairman, had a political influence and misappropriated the funds of the company, as a company was in loss. Now, the second aspect that happened was uh, there were administrators who were appointed in this particular company. And subsequently, what had happened was that what was dealt in this case was that company being in loss and the money being taken outside the company is a fit case for the purpose of operation and mismanagement. Thereby, this was one such case which got decided under the reams and the ambits of the courts. Next. Aruna Oswal. Now it has been decided, it was decided in 2022, if I'm not wrong, by the Supreme Court. This is one such case where addressing the sale of shares was one of the important aspect that was being decided in a particular company. Here, the case highlighted issues such as misusing of, again, the company funds, treating minority shareholders unfairly, emphasizing that the case also had served as a means of a benchmark as to how a corporate governance should be run inside the particular company. To address these problems, insofar as this company was concerned, the other side, that is the Pankaj Oswal, was ordered to sell their shares to a third party to provide the relief to Aruna Oswal and affected shareholders. So thereby, the subject matter that evolves is, in such cases, when there are complaints of ownership, these go on up till Supreme Court. And thereby, if not addressed at the threshold levels and the stage, it can be a cause of continuous litigation action and can spiral down till the time the ego of the person does not get satisfied, or the person does not feel that he has got a satisfied judgment from X court is concerned. He may keep on fighting till the fag end, because at the end of the day, it's about the ownership of a particular company, and most of them are very close to the company which they build, and thereby they ensure that they fight till the last. So thereby, yeah, battle of egos and greeds are a constituent of an important factor for all of these operation mismanagement cases. Next. Now here, many a times we find that cases gets filed without even having any shareholding in a particular company. People start filing operation and mismanagement cases without even being a member of the company and holding any 10% shares. Or thereby, what is happening is that this one such case where the shareholding itself was not there of a particular person, and he approached the tribunal. And thereby, what had happened was, there is an NCLT rule that first you ensure that you establish that you are a member in a company, and then you come and litigate your matters or talk about the relief. Thereby, at the threshold level itself, the petition gets dismissed, if at all, if you are not able to establish that you are a member of a particular company and holding the requisite percentage of shareholding. Next. Non-member, same thing, which I had already discussed many a times. Like we say, the percentage of shareholding, non-members, creditors starts filing with reference to cases. Thereby, what happens itself is people get dismissal orders on account of the fact of no locus. A creditor can actually approach under the 221 of Companies Act, read with 206 and 213. So thereby, those sections are applicable for them. 241 does not take a root, because of the fact that under 241, you need to establish. Somebody has written a question. If minority shareholders as perfect proof of mismanagement and operation, but they all agreed put together are more than 100 shareholders, but not holding 10% of shares, then what's the recourse? Yes, 244 is the recourse. Mr. Kishore Faria has asked this question. 244 is the recourse, sir. You can apply to the NCLT stating the affairs of the company are run in this particular manner. You may not have the 10%, but it is alarming, or it shows that the issue that needs to be addressed is of that kind of a magnified manner, which is causing irreparable injury to the other side, that is you. Then in such a case, you can always take the route of the NCLT, even though you may not have 10% shareholding, On the basis of facts of each of the case, the NCLT will determine whether the acts which are being complained of needs a consideration or does not need a consideration. Thereby, like I said earlier as well, even in Tata Mistry case, the 10% issue was there, which that basically the Mistry did not have the 10% requisite shareholding. And thereby this particular case was dealt till the end on account of the fact of the exceptions which are being given, stating that it is important to deal with such issues since it is affecting the whole company at large. Next. Pleasure, sir. Battle of egos, like I said, this is purely a battle of egos. Most of the times, one person may not want to settle with the other person, and thereby, next slide, please. So thereby, what happens in most of the cases is that people don't want to settle and take the route of litigation. Now, this is one more case which was dealt in NCLT Mumbai as recently as in September 2023, if I'm not wrong, where initially what was being claimed was the interim relief. Now, what do we talk about? Basically, in operation and mismanagement cases, first thing that needs to be seen is that whether you are getting an interim relief or not. If you're not getting an interim relief, it is a long-term battle. First, you need to get an interim relief. That is the first stepping stone for the purpose of the operation and mismanagement cases. Now, if you get an interim relief, then you can be rest assured that even if the case goes for a certain period of time, at least for that juncture, that act or the actions are being stopped to that extent. So thereby, getting an interim relief is one of the most important aspects. Now, how the interim reliefs are given is on the basis of 3 points. Prima facie, you need to have a case. Balance of convenience needs to be there in your favor, and irreparable loss or injury should happen to you. That is to say, if you are not given a interim order, then it should be such that it makes you feel redundant. So thereby, in this case was such that one set of group of shareholder wanted to invoke certain arbitration in Singapore, where it had the seat, and thereby it would make the whole operation and mismanagement case filed by Anupam Mittal to go to the bonkers. So thereby, what had happened in this case was the NCLT took recourse that if today interim relief is not granted, then the subject matter, which is the shares which are getting decided in that arbitration, and if such an order is passed in an arbitration that exit is given to the shareholders, so on and so forth, then typically what would happen is that the person may not be able to have any form of the person may not be having any form of recourse in operation mismanagement case at all if the shares are being sold. So thereby the whole aspect of the ream of the whole discussion was such that the NCLT has the power to grant the interim relief, and the whole agreement was drawn in such a manner that it had to be decided in Indian laws, whatever the subject matter was, and thereby arbitration to be done in Singapore did not hold that kind of a water. And basically the NCLT prima facie, without getting into the merits of the particular case, considering the fact that it would render the whole case itself to become infructuous, had dealt in this manner where it had given the interim relief. So that is one of the things that had happened recently in the Anupam Mittal case. Anupam Mittal is the same person, Shadi.com, and which you see, as well as the Shark Tank, the gentleman who appears in that. Next. Kirloskar Brothers Limited, this is Atul Chandrakant Kirloskar. This case is with reference to the fact that Mr. Atul had approached the NCLT, that the board rejections of their pre-clearance request to buy or sell our shares. And typically what had happened, this was alone decided 5 days back. And here, if we have to say, what was decided was that indeed there is operation, indeed there is some part of it which is happening with this company where certain oppressive acts are being committed, and winding up cannot be proceeded with since the company is large enough and has a lot of legacy. 60,000 shareholders are there in the company is what was decided, and the company was almost 100 years old, and thereby what was decided was that the person can buy the other person out, and that can be done within a manner of 30 days. If that does not happen, subsequently the other person can take it out in the market to offload his shares, so on and so forth. That is the acts which are being complained of. To bring an end to it, the NCLT takes a decision insofar as this particular case is concerned, that you buy out the other person out. So thereby, this is one such case. Next. Invesco Developing Markets Fund versus Z Entertainment Enterprises Limited. Well, Invesco called an EGM and removing 3 directors, so on and so forth, including managing directors, CEO, so on and so forth. Now, what had happened was the single judge had granted that relief under the provisions of Section 169 of Companies Act. By virtue of EGM, you can remove the directors. Now, first single judge had provided some form of a relief to them, but after that, the division bench took the Invesco's appeal against this, and order passed, appeal against that order passed, it had reversed and stated that under the pretext of 169 of Companies Act, so on and so forth, all what is required to be seen is whether the procedural criteria are getting satisfied. If that is getting satisfied, then the shareholders have all the power to remove a particular director. And thus, this was one such case which was dealt vividly in the public domain. Next. Here, now operation, what kind of operation can come under the operation and mismanagement cases? This Alakappan, Arunachalam, Murugappan, this is Valli Murugappan case. This case was a family dispute. Here, in the history of Murugappa family, there has not been a single woman who was ever been able to be in the dictating in the board or any form of affairs of a particular company. So thereby 8.5 or close to 8.2% shareholding was there between the two producers come by routing the funds. Somebody has put a question. Would it be a fit case of operation? One of the directors appropriated the sale proceeds of capital asset. I'll come back to this. Let me complete this particular slide and I'll come to this question. So now in this case, what happened was that, like I said, it is a battle of egos. So thereby the ladies also did not allow the gents to get away from this particular domain of ensuring that the company is being run by them and they not getting any share of the pie in the whole prospects of a particular case. So thereby what had happened was that there were two options. There were two options which are being brought forward. That is with respect to their plea was maybe take us onto the board of the particular company, or you give me a fair deal so that I can walk out of this particular case. So 8.2%, which was there with the aggrieved parties, that is the ladies, that was subjected to the other party, wherein the valuation was first offered was very less. And subsequently, after the legal battle, after the NCLT Chennai gave its judgment on part of the case, nothing on merits, we had substantially traversed. But NCLAT also affirming the aspect of that particular order. But the facts of the matter were not in so far as dealt about the merits. And subsequently, the parties came to a settlement. That is, the Murugappa group went on to settle the Valli Murugappan and the other ladies in so far as the 8.2% shareholding, wherein they decided to settle the shareholders and pay them and get the shareholding back in their hands. So thereby, even gender discrimination or so on and so forth can also act as a means of an oppressive act, where a person can go ahead and also claim that in such kind of cases, NCLT can be approached. Next. Union of India. Now, chartered accountants are one of the most aggrieved person in so far as the NCLT is concerned. Many a times when operation mismanagement cases are filed, one of the parties that are being made are the independent chartered accountant who signed the audit reports. Now that also becomes one of the, in ILFS case, this was there. with respect to the fact that application under proceedings under 140 of subsection 5 is held to be maintainable even after resignation of the concerned director auditors. Here, what had happened was the plea which was taken in the Deloitte's case was that since they have resigned and since they have walked out of the as a auditor is concerned, they are no more liable to take this forward. And the High Court had given an order in favor of that, thereby which was reversed by the Supreme Court. And Supreme Court had said that even though you may have resigned from the particular company as an auditor, the act and the actions done by the company does not go away. So thereby, this being said, the next set of aspects took progress in the particular company. So thereby, as chartered accountants, what matters is that in many of the cases, first you need to see where they make you parties, whether at all you are made a pro forma party or a main party. That is one thing that you need to understand of. What do you mean by pro forma party? Pro forma party is one party who assists the it's a form of a kind of a witness which may be called up in a case at a later point of time if the case develops further. Now, if you are made a main party, the first thing that you need to look at is whether there are any relief which are claimed against you. That is, whether they are saying that such chartered accountant should be reprimanded, he should be done X, Y, Z, so on and so forth. Some action has to be taken. He should be reported to the Institute of Chartered Accountancy of India, to a disciplinary committee, so on and so forth. Any such prayers, if it is there, then it is logical to make you a party. If there is no such prayer which is against you, then in such a case, you can go to the tribunal and ask the tribunal, since the relief is not against you, thereby you may be dropped as a means of a main party, and you may be made a pro forma party to assist the court at a time, if at all, if there is any assistance, which may be required by the court at a later point of time to address the issues which are being complained of. So thereby, as chartered accountants also, we should know our realm, domain and scope of things with reference to how we are made a party, whether at all we should be made one, or there is anything which is claimed against us. If it is not claimed against us, why should we go to the court on a day-to-day basis when that is not a subject matter which is concerning us? So thereby, at the initial start itself, the chartered accountant can raise an objection if he is made a party and there is no relief claimed against him. Next. Byju's case, well, everybody knows a lot of things that have happened in this particular company. 4 investors went and filed operation and mismanagement case to conduct EGM, to appoint new board, declare the right issue as void, so on and so forth. Byju had filed the petition under arbitration to restrain investors. It was allowed basically investors to conduct the EGM. Basically, if somebody moves ahead with removing a particular director, so on and so forth, under 169, there is no prospect as to they can technically hold that stuff. And thereby now what has happened today is that till now that issue is getting decided, and the next date of hearing it has come in the NCLT is June 6th. That is when the issue will be decided. But the main cause of action, or maybe that can be put forward more than the operation or mismanagement, is with respect to the fact that the expansion of this company in a widespread level on the other countries, where consolidation of accounts itself became a huge problem for them to bring about to the books as to what was going on inside the company. So thereby, consolidation and having operations in other companies also at some point of time plays a huge role. When there is no seamless flow of information flowing in a particular company, that may also become one of the issues, how a company may not function in its true capacity, because in one country there may be some requirement of accounts, in some other country there may be some other requirement of accounts and dates which are being postulated. And when there is too much amount of expansion, this also becomes a form of a problem, because initially Byju's was not able to give any details in pertinent to their accounts at the initial levels. Next. Well, this case was something which I was part of. There were close to around about 11, 12 other side respondents. And with reference to the order which was given, the interim order, this is one such case where classic case where Next slide. When the whole prospect about operation and mismanagement starts from the fact that how an interim relief does not get granted to an aggrieved person, and how he takes that case to the next level insofar as claiming that relief, and thereby what how the strategies are to be worked upon is what was one of the aspects that needs to be looked about in this case. And there were close to amount about battery of 36 odd lawyers who had there with big names which were there in this particular case, and thereby starting from the interim order, I'll just showcase as to how on a practical case study basis how these strategies work, and how a promoter can also be protected if in case there are investors who pile up certain other aspects in a company which is against the spirit of the whole aspect of running a company. We show that order. Before that, I can take out the question. One of our reported cases of Binny Limited, wherein forensic auditor has reported diversion of 800 crores funds by promoters in related parties, but no action taken by any regulatory bodies. Action under which, yes, just put the slideshow on. So action, but this is not showing in this. Actions taken by any regulatory bodies. Action under which section can help in bringing back these funds back in the company. Actions can be many, sir, insofar as if in case forensic auditor has reported diversion of 800 crores, then there are so many cases which can be filed. One is with respect to the fact that apart from the Companies Act, you can file under the 405, 406, 415, 416, 420 of IPC. That is with reference to the criminal breach of trust, with reference to the fraud, insofar as all this. Ensure that slideshow is on. No? Yes. It's on. Slideshow. No, slideshow. Yeah. So the sum and substance is that you can file under 405, 416, 417. A complaint can be filed with the authorities. Under 206 of Companies Act, you can file a complaint with the authorities. You can log in with the MCA portal. You can do that as well. And apart from the fact that you can also file with the EOW, if at all, if there is such a kind of activities which are happening in the company. Apart from that, you also have other avenues which are there where you can directly go ahead and file such complaints at all these places where such diversions of funds have taken place. And apart from that, you also have other ways and mechanisms through which this money can be even gone through the purpose of Income Tax Act for the purpose of such kind of either the recovery or the complaints, which can ensure that some or the other you can get a settlement out of this. This is a separate issue altogether. So let's look at this order. This is an interim order which we are technically talking about, which at the first level, first stage of the case, we were not a part of it. And you sit down. And at the second stage, that is when this particular case was taken out for a purpose of appeal, you can see that senior counsel so and so interim relief sought by the petitioner is not granted. Kindly see this. This is one particular line which led to the spiraling of another litigation at the next level. Now, what this case was all about? There were circular resolutions which are being passed by one group or a faction of shareholders, directors, who wanted to take control of the company through an insolvency professional based out of Singapore, because the parent company had become insolvent and an insolvency professional was appointed in that particular company. They wanted him to run this company, which is based in Chennai. So now what had happened was they passed a circular resolution where they did not send any of these resolutions to the petitioner. But what they did was they sent these resolutions to the lawyer. Now, the first question which I would like to ask, whether a lawyer is supposed to receive the resolutions or a director is supposed to receive a resolution insofar as someone else is going to manage this company or you're getting removed. So whether any such board resolution which is getting circulated, who is supposed to receive that resolution? Either a consider whether a consultant is a competent person to receive that particular board resolution, or the director should receive that particular board resolution. That is the first question which comes into the picture. Now, when this question was asked, the subsequent aspect which came into in NCLAT, because the first interim order I was not there. In NCLAT, when we took this particular matter, next page, please. When we took this particular matter, next page. When we took this particular matter where the interim relief got granted was on account of the fact that it was not circulated, it was against the prospect of an AOA, and mind you, it was hotly contested one, which went on for a period of almost 1.5 years with 14 days of full day arguments on this particular company in NCLAT in order to get a final order. Kindly share the final order, please. Now, what was decided and what is the strategy that we are talking about? Well, basically, when we talk about this particular case, there's only one person who is fighting this case against close to around about, how many respondents are there? There are close to 11 respondents in a particular company. And in this particular case, you would find that all the respondents had technically resigned from the company. Now they say that yes, we passed this resolution, but we have resigned from the company. Now there is nothing which is there with reference to this case. Let this case, get dismissed on account of becoming infructuous. So thereby, what was the actions which were being brought about? What was this case all about? This case was technically all about that an act and action done by a particular person does not go away merely by him resigning from the company. That is to say, in all our elementary basic Companies Act education that which we have studied, the first thing that they talk about is men may come, men may go, but the company goes on forever. Thereby, if a man has already gone, his actions does not go away. His actions have got inscribed in a particular form, and thereby when he is filing some form with the registrar of companies, it becomes an act of a particular record, permanent record, and that cannot be removed by some form of an eraser. It has to come only through a form of an court order, and when such orders are being given, that is when you are able to get the whole oppressive act vanished. Now, what was the strategies which were adopted? Now, once the case received before it received the final verdict, the stay was already given. Once a stay is given, stay usually gets continued to the next stages of hearing each time. So when we see this, now what had happened was cases upon cases were being filed by the respondent in NCLT, accusing of lot many things in the same main case. That is to say, if there is a case, the earlier case which we had shown, 794, where interim relief is not granted, they'll keep on filing one IA, second IA, third IA, fourth IA, fifth IA, so on and so forth. So thereby, at this juncture, when we had taken this case and we had categorically won it in NCLAT, we said we have already got the relief in NCLAT regarding this case, and we do not want to further take the case up in the NCLT. I do not want to again come back to NCLT and argue this matter since I have already won in NCLAT. I want to withdraw my whole case. I have got the relief, and 25 cases which were filed by the other side in IAs, in IAs, and IAs. Once you withdraw the main CP, all the cases filed becomes of cards fall, because the main CP, once it gets withdrawn, the whole cases comes to a closure. That is one part of it. The second aspect to this is the freezing of shares, which was being done by the company secretary, was on account of the fact that the other side had not shown their beneficial ownership. which is also one of the most important constituent for a particular operation and mismanagement case for larger entities where such things come up. So thereby, in many of these cases which starts off, first a person should know how to take the case through, what are the drill down strategies, what are the what are the slumber mode strategy, what is the all faced strategy in terms of where you keep on filing cases upon cases upon cases, where you finally ensure that the other side comes to the table because he does not want to fight any other case with you. That is one way of ensuring a pressure on the other side, where he comes to the table to discuss and close things off. That is one part of it. Otherwise, insofar as all these cases are concerned, litigation is the only aspect that can be spoken about, and it can be taken through, because there is one thing that can be done by the men, but the other aspects can only be done by lordships who are there in the court, who are there to decide if people don't decide the disputes among themselves. That is to say, if operation and mismanagement cannot be handled at the first level on account of whatever mediations, whatever prospects, whatever strategies which you apply for, then the only way to take this thing up is through the mechanism of courts, where that also is another aspect where you need to have a good think tank in order to ensure, as a chartered accountant, that the reliefs are being got by your client. So this is some of the things which I wanted to discuss. As a means of a fact, 2 hours was allotted to me. I'm sorry for the glitches which has happened in so far as the start of the presentation is concerned, but more or less we have covered in so far as operation and mismanagement is concerned, as to broadly as to how things are to be meted out at first stage. Then if the cases take up to another stage, then how to take it up further. As a chartered accountant, what needs to be done if at all your name comes up as a means of a party, and subsequently what are the roles that you can play prima facie, if in case you want to be a part of it as a means of a mediator, or you can also argue the matter as an authorized representative if you want. So this is in a broad nutshell which I wanted to highlight. How there are a few questions which are put forward, sir.
Yeah, in Q&A section also there are two questions are there, if you just refer. First question is from Mr. Rajendra. Mr. Rajendra Wal, how a shareholder having 2% interest can be protected? Majority shareholders do not share information such as notice of board meeting, AGM, no sharing of communication with statutory auditors. Such minority shareholder is also a director. I think there is a threshold of 10%, and here the only 2% is the shareholding. So how it can be protected? That must be the focus.
Protection can be terms in terms of shareholder activism today is gaining a lot of impetus. If you have to see the shareholder activism, when I talk about, you can always write letters to the ROC stating that as a means of as a means of as a means of a shareholder, you are not getting any notices, etc. So as a means of a shareholder, you are not getting any details pertinent to the notices, you are not getting details pertinent to the AGM, so on and so forth. Because one part of it, when you file a complaint, as a matter of fact, today all the ROCs, all the forms are centralized. So the only work that today is left over is to start any form of an inspection, investigation, or do certain report related activities which are there for mergers and other aspects of it. So condonation or compounding. So these are the works which are there with the government department. So once you file a complaint, there will be an activism which will get started by issuing of notices by the ROC to the errant company who are not doing X or Y or Z thing which you technically want. Yes, next. Ramchandra Panuganti. World directors giving unsecured loans at higher rate than bank considered as mismanagement. Well, mismanagement, whether it is there or not, is subjectively depending on the facts of the case. Then the subject matter is world directors giving unsecured loans at a higher rate than bank is considered as mismanagement or not. See, whether it falls under that or not is a subject matter that needs to be dealt in the facts of a particular case. But there are certain legislation available at state levels, with most of the states having the usurious interest based legislation which are adopted, wherein you can go file and complain if there is some aspects of going interest being beyond 18%. So many of the states have this usurious interest related enactments which can be made use of in this subject matter.